Hi there, I'm Ken Lammers, your host, and you've reached Cltv. This week's topic has been, or this week's episode has been titled Hubris because, well, I'm going to disagree with a judge from the Fourth Circuit of the United States Federal Courts. And I think that's an apt title. So, let's get to it.
The number you have reached, 911, has been changed to a non-published number.
Hi, Ken Lammers here. We'll let y'all know ahead of time, this is the third time I've tried to film this thing. First time I tried some experimenting with stuff and it went terribly wrong. The second time I tried it and I forgot to turn the mic on. So, you know, all the very insightful points I had to make and all the humor that I had has kind of all been expended in those two shots. This one may turn out okay, we'll have to see, but you know, I'm just doing my best at this point to get something done, to get it out. And with that glowing recommendation of what I'm about to do, let me move forward. Now, what I'm talking about today is something having to do with Judge J. Harvey Wilkinson III. He's a judge on the Fourth Circuit Court of Appeals of the United States. He has been considered for the federal bench, the Supreme Court federal bench, I should say. Has been a favorite of some people for that. And, you know, all around, theoretically at least, a very, very bright man. I've never met him. So, I don't know, but, you know, I assume that most people are sitting on a federal bench are smarter than me. I hope that most people sitting on the federal bench are smarter than me. Anyway, he is talking about, it's a law review article for, I think it's going to be published in UVA, titled Of Guns, Abortions, and the Unraveling Rule of Law. His thesis in this is that Heller and Roe, Heller being the gun case recently, the firearm case, and Roe being, as we all know it, the abortion case, are flip sides of the same coin. Both of them are abuses of the judicial system in favor of basically legislating from the bench, and he disagrees with these and sets out what he thinks. First section, of course, is the introduction, and he talks about, well, basically it's a brief overview of the shortcomings of both, what he sees across both of them. The flaws of both Roe and Heller are that there's an absence of a commitment to textualism, a willingness to embark on a complex endeavor that will require fine-tuning over many years of litigation, a failure to respect legislative judgments, and a rejection of the principles of federalism. With the exception of the first one of those, I think that they're probably correct. First one's absolutely wrong as far as it goes with Heller. Now, what he calls for, and I'm going to call it Wilkinson's rule of restraint, and he says, when the channels of democracy are functioning properly, judges should be modest in their ambitions and overrule the results of the democratic process only where the Constitution unambiguously commands it. So that's basically his rule of restraint. You know, you don't do anything unless the Constitution commands you to. You leave it to the legislature. It says the flaw of the two cases is this. In both Roe and Heller, the court claimed to find in the Constitution the authority to override the wishes of the people's representatives. In both cases, the constitutional text did not clearly mandate that result, and the court had discretion to decide the case either way. And then he goes on to talk about how basically Heller is a triumph of originalism, and how from now on everything that conservative jurists do, all conservative jurisprudence is supposed to be originalist. I agree with him as to the flaws of originalism. I don't necessarily agree with him as to, you know, talking about how everything's got to be done as an originalist now. An originalist effort. I just don't buy it. Now he goes on. I mean, he sets up 4 different sections, and First is fashioning a novel substantive right. He claims that there's both in Roe and in Heller, there was a brand new right that appeared out of whole cloth from the court. While I would agree with that in Roe, it's clearly not the case in Heller, and I'll explain that in a little bit. 2, he goes into, it makes the court descend into the political thicket that, Roe caused and Heller will cause a whole bunch of litigation trying to decide what the parameters of the rights are and everything like that. Got to agree with that. That's actually happening and will continue to happen for a while with Heller, and has happened for a long time with Roe. 3, ignoring the legislature's strengths. Yeah, well, I mean, the legislature has strengths. It also has weaknesses where it's stuck with things that, power groups in that state or, are able to ram down the throats that would not be agreed to by the regular person, or things that clearly invalidate the rights of a regular person. So I don't know that that's necessarily a strong argument. And somewhere in here in the political and the legislative section, he talks about, I think it's in the political section, he talks about, how, like Roe, Heller will cause everybody to descend into a whole bunch of litigation, and talks about, what will it do to, right to have a concealed weapon. Well, the Constitution says you have a right to bear arms. It doesn't say you have a right to conceal them. And he quotes part of the decision itself, Heller. Nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms into sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sales of arms. And goes on further talking about prohibition of dangerous and unusual weapons. And talks about how this is problematic because, you've just said there's a Second Amendment right to bear arms. But I think the problem here is this. Now, at least with the mentally ill and felons, at the very least violent felons, there is, when we convict them, we take a right away from them. Absolutely. We take the right to liberty away from them. We stick them in a jail or a prison. Or at least we put them on probation where they're watched and, with that threat of going to prison or jail. And I believe that, if we can take that right from them, a right to bear arms would also follow, something we could take. Now, as to the outside limit of what you can own under arms, clearly, arms means a lot of stuff. It doesn't just mean a rifle and a pistol or something like that. Arms means munitions, and arms mean big guns. And so, if you got a right to bear arms, the clear language there would be, bear arms would mean I could have a tank in my yard if I could afford it. And then, of course, the government's never going to, no court is actually going to find that. He moves on further. Outside of those two sections, he talks about how, in his last section, outside of his conclusion, he talks about how this is all, both Heller and Roe are about disregarding the Federalist virtues, the virtues of federalism. Both of them take away a traditional state authority. Well, the feds have been messing around with firearms for a while now. Anybody who's heard of the word Project Exile knows that. So, that they're obviously not really taking away a traditional state power here. 2, defeats federal design. And this is kind of an interesting endeavor in fitting something in. 1, federal design is to conform to the locality so that the most people are happy. Basically saying that, if everybody in California wants pistols and rifles to be outlawed, they should be able to do that. And if everybody in Texas wants to make the law so that everyone has to carry a pistol or rifle, they can do that. And therefore, everybody in Texas is happy and everybody in California is happy, and they both think the other side's nuts, but they're happy where they live. And once a law or a rule is passed through the court, that doesn't happen anymore. And I gotta agree with that. That's a pretty solid rationale. B, state says laboratories or laboratories, however you want to pronounce it. This is a really kind of a weird idea. The whole, well, we'll let the states mess around with it for X number of years until somebody comes up with the perfect answer. You know, quite often nobody comes up with the perfect answer, and eventually the laboratory has to be shut down when you make a decision as to what's going to be what. That's really a bad reason to argue for federalism. Federalism protects rights. It's supposed to put the state and the federal government at odds with each other, and in that tension, the people preserve their rights. Yeah, right. If you believe that, I got some bottom land to sell you, you know. And, you know, doing away with federalism stops the ability to reach compromise, which is somewhat true. I mean, you know, you can reach compromise in your state legislature or, you know, local town council or whatever. Eventually, you can reach some sort of compromise. I don't know that it works so well in the federal system, but it would work there. Still, eventually, in the end, since you're going to have 50 states with 50 different rules, something's got to happen to make the rules the same if you're actually going to reach a compromise overall. So, I don't know. The federal design thing is kind of out there as to most of the points. Now, you know, all that's kind of beside the point because, I mean, it lays it out and it's his argument. What he does is he conflates effect with, you know, interpretation. You know, the effects are over here, and he sees the effects as bad. And, you know, some of these effects are going to be bad. I got no doubts about it. But over here, he's got, you know, the reasons that we're going in and interpreting such things and acting on the Constitution. And they're not the same. You know, you can have bad effects on a good constitutional interpretation. It is, well, that's just the truth of it. And his a priori foundation for his entire argument is that both Heller and Roe are based in ambiguities in the Constitution and therefore should have been left to the legislatures to make the decisions and the court should have left it alone. Problem is that, you know, yes, Roe, there's a lot of ambiguity about Roe. Where do you find the basis? The penumbras? Is there a right to privacy that perhaps is preserved under the 9th Amendment to the people that the government then can't go after? And then, you know, what about the unborn? You know, is there, or do they have any rights, et cetera, et cetera? You know, it's really ambiguous. It's a really bad place for the court to be. The problem is that Heller doesn't get there. And let me tell you, I'm going to give you at least 3 different examples of Judge Wilkinson making this ambiguity claim. First is, in both cases, the constitutional text did not clearly mandate the result. Second, the majority read an ambiguous constitutional provision as creating a substantive right. Third, both cases interpreted ambiguous constitutional provisions. Okay, there's ambiguity behind Roe. The problem is that if you really want to do a textual examination of it, there's no ambiguity in the decision of Heller. Now let me, and you'll notice if you read through this law review article that Judge Wilkinson steers well clear of textualism. Matter of fact, it's basically a paragraph, maybe a paragraph and a half, and here's the meat of it. Does the amendment's prefatory clause limit the scope of the right found in the operative clause or merely explain the justification? Justice Scalia, rejecting the arguments made by professors of linguistics and English to the contrary, dismissed quickly the possibility that the prefatory clause could restrict the operative clause and concluded that the right in the operative clause need only be consistent with the announced purpose in the prefatory clause. Justice Stevens, in his dissent, called this approach novel and not in keeping with conventional interpretation methods. Okay, so, and he blows right past that and goes on about talk about originalism. Now, the textual argument is pretty clear. What he's calling a prefatory clause, I'm going to read you the prefatory clause he's talking about is a well-regulated militia being necessary for the security of a free state. That's the prefatory clause. Okay, now, the operative clause, the imperative clause, the ruling clause is that the right of the people to keep and bear arms shall not be infringed. Okay. So, basically, we've got two independent clauses here. Now, it's not written that way. It is what we would, in modern era, think very grammatically poorly written statement. It should be two independent clauses. A well-regulated militia is necessary to the security of a free state. Period. The right of the people to keep and bear arms shall not be infringed. Period. So you got two complete thoughts there. And one's an explanatory thought and one's an operative thought. Okay. And if you've gone through high school English or junior high English or middle school English or whatever your schools call it, and you've done a sentencing diagram, I invite you to go do it. Because you will go through, and we all end up with slightly different sentencing diagrams depending on whether we think things like infringed is a gerund or a some sort of infinitive, blah, blah, blah. But what you're definitely going to find is that that prefatory clause does not modify anything in the operative clause. The subject is clear, right? The predicate is, shall not be infringed. So, there is no, there's no ambiguity here. And if you go and engage in using the prefatory clause, the independent clause at the beginning, to interpret the secondary clause, you're basically engaging in what could both be called legislative history or originalism, to negate the clear and unambiguous language of this amendment. This entire paper fails because the foundation, the a priori foundation of Judge Wilkinson's paper is that there's ambiguity here, and there's not. I'll go further, and let me explain this to you. Now, the first independent clause, right, I'm going to substitute some words in there so that you can see how clearly the second one stands alone. Martians being green and having welts, the right of the people to keep and bear arms shall not be infringed. So, you still understand very clearly the right of the people to keep and bear arms shall not be infringed, even though the first part of that sentence, substituted in for the prefatory clause before, makes no sense, or at least not in the context. You clearly get what the last of it means. There is no ambiguity here. And you can try to shoehorn it in all you want, there just isn't. And so therefore, this paper, which is well put together and obviously well thought out, and there was a lot of crafting went into it, just doesn't make any sense. I mean, it fails. I don't want to say epic fail because that'd just be cruel, but it just fails right from the beginning because its foundation does not stand up. And that's the way I see it. Anyway, ladies and gentlemen, I think that's going to be the end of the Cltv this week. Next week, who knows what I'll be putting up. Somebody asked me to put up to talk about stories about clients, how clients as defense attorneys act or how defendants act. If you're really interested, go down the right-hand column. There's a whole bunch of posts I put up about when I was doing defense work, and a lot of that's going to talk about clients and how they act and their families, etc. But I don't think I'm going to go forward and put things like that on the Cltv anytime soon. Who knows what I'll put up next week? We'll have to see when I come time for me to put it up next week. Until then, y'all have a good week, and I'll see you then.